Olive?
I was acting as a mouse, on a cheese. It's a deadly combination. The mouse and the blue cheese, as they say.
Only virtually. Only virtually.
But I've gone vegan, so cheese is out of question. Yes.
But if I can just step back from the note for 1 minute, because a lot of material has been used before, a lot of submissions have been made. But my attempt in the rejoinder is to, in one sense, give some order to this material. I'm not the first point I want to make to your lordships. I believe that this is a not significant point given the time spent by my lordships. But it is a conceptual error to conflate the idea of voidness, whether it is voidness ab initio or otherwise, with the doctrine of revival. I'm not going to tell you, Lordship, why I say this. But and I was fully conscious of this when I made my own, and therefore I didn't elaborate on the aspect of voidness. Voidness is something that goes with the declaration of unconstitutionality, as your Lordships make it. But it is a doctrine which deals with the effect of Lordships' declaratory order statute. It makes no difference in my respectful submission whether it is sure. But the cases are settled on this aspect. The effect is to rob it of all legal effect. It becomes legally destitute. Now my learned friends for arguments proceed on the basis that because it is void, we must treat it as factually non-existent in the statute book. But in my respectful submission, that is to conflate two different concepts. I tell you, Lordship, why. But I understand this requires a little bit of explanation. Bear with me a minute. But I don't think there is any dispute about the fact that your Lordship's declaration, and I'll deal with the different types of voidness because I noted carefully what my Lord the Chief Justice put to me the other day. Lord, renders the decision void at some level. You may say void on the date of the declaration. You may say void on the date of insertion. You may say void on the date of amendment. But all of those are statements which go to the legal effect of the remaining language. That, in my respectful submission, is not really the point that we are grappling with. The real point that we are grappling with is a question which is apart from this. It is the question of whether the old provision can be resurrected or come alive again. Now, my learned friends in their argument, and I notice
their argument is that the old provision never died in actual
life. It is always latent and it is always there.
Because because the process by which the new provision was sought to be inserted in substitution of the old provision, that itself was stillborn. So in that sense, it was not the substituted provision which ceases to be of effect, but the substituting provision ceases to be of effect.
I fully appreciate that point. And my response to that point, Lord, is twofold. But one is what I've already said, the perennial theory. But we may regard that as some sort of abstruse doctrine of constitutional law. So, Lord, I actually have a better answer for you. Lord, and the answer is this. Lord, that when we declare something to be void, we rob it of legal effect. Lord, it is something that courts do day in and day out. But the voidness doesn't carry with it the consequential actions which may follow as a result of the voidness. But in this case, the legislative cleanup or the legislative sweep up or the legislative reenactment. Now, when your Lordship puts it to me to say that, as my learned friend Mr. Shankar Narayan put it, that in fact it's never dead. Lord, I respectfully disagree, but I see a situation where that could be the case. Lord, where under Article 368(2), the procedure for bringing about a constitutional amendment has not been followed. The law has never taken effect as prescribed by 368(2). It is entirely possible to say that the old law has not been dislodged and the new law has not become alive.
So, but if the basic structure is a limitation on the amending power itself, in which case, compliance or consistency with the basic structure is a condition precedent to a valid exercise of the amending power.
I see that point.
And then if the condition precedent is not fulfilled, then the process of substitution itself never took effect.
So let me immediately try to answer that point.
And that's why the declaration that section 4 was void was all that was necessary. They didn't have to go all the way to say that 31C is void. Because if the substitution had taken effect, they would have had to declare 31C as void, which they never did. They said that section 4 is void for the reason that the substitution was never carried out as a matter of constitutional doctrine. That seems to be the line of argument.
So, but let me try to answer your Lordship, Lord, with 3 or 4 points. But the first is this, Lord. There are various types of voidness. Lord, voidness for lack of legislative competence. Voidness for
breach of fundamental rights
under part
any other constitutional limitation and basic structure.
And basic structure. Now, Lord, basic structure, Lord, has actually received its own nomenclature, as your Lordship has noticed from Minerva Mills. And the correct nomenclature, but we don't need a new nomenclature for that, is beyond the amending power of the Constitution. That is the language which is consistently used when it comes to basic structure. So, Lord, we are in a situation, although a judge-made situation, of akin to legislative incompetence. Akin to it. We are in a situation where it is a limitation on the constituent power. Therefore, my learned friend, Mr. Dwivedi, used language with regard to the using constituent. But it has already been dealt with by our courts. And what they say is that it is
now
beyond...
because the basic structure doctrine is a limitation on the amending power.
Yes, sir.
And something which is done in violation of the basic structures beyond the amending power.
Ma'am.
That means that exercise itself has no constitutional...
so, Lord, does it mean that is what I just want to
It
explain?
has no constitutional foundation. It's not that you have enacted a valid law, inserted it into the statute book, and then law happens to violate part 3 of the Constitution.
Madam.
Here, it's a situation where you've acted on an area where you had no power whatsoever. You are beyond your amending power.
I follow.
In which case, it doesn't enter the process of an effective constitutional amendment. It doesn't enter the constitutional fabric of 31C. It remained at a stage anterior thereto, namely an exercise by the Parliament purportedly in the exercise of its power under 368(1).
I follow what the Lordship says. But my response to your Lordship, my respectful response to your Lordship, Lord, on this point is this. Lord, the lack of constituent competence, Lord, which is the basic structure point, Lord, is very akin to the situation where there is a lack of legislative competence. It is almost identical. Lord, and therefore, Lord, I thought a great deal about this. Lord, there are many cases which deal with lack of legislative competence in the context of normal statutes. But in
There's one critical difference.
Yes,
where there's a lack of legislative competence, the power to enact the law vests somewhere in the system.
Yes.
See?
I follow
Because
what Lordship said.
in the case of a breach of the basic structure, that power does not exist in any organ of the state.
Lord, I accept what your Lordship says there also. Lord, so the basic structure doctrine is an implied limitation. It is an implied limitation which prevented that particular amendment from being passed. Lord, I accept everything that your Lordship said. The effect, therefore, of your Lordship's declaration of unconstitutionality, let us take it at its strongest, declares it void ab initio, as if it never existed. But my Lord, my point to your Lordships is this. The statement of voidness is a statement limited to legal effect. Now, Lord, allow me just to elaborate this. Lord, what happened, Lord, with regard to this particular amendment? And Lord, and I just want to draw a distinction where I believe that your doctrine, Lord, holds, where what your Lordship put to me holds true. But if your Lordship takes up my note for a minute, Lord, I have set this out to just prevent us from having to go elsewhere for it. But please come to paragraph 16 at page 111. Now, my Lord, my point to your Lordship is this. And here I want to deal with one of the points raised by my learned friend, Mr. Dwivedi. But paragraph 16, if your Lordships have it, at 111. But perhaps at paragraph 15, your Lordship will get a broader idea of what I am saying there. But the point, another way of looking at the point, is the point which was also made by some of my learned friends, Lord Mr. Salve, Mr. Dwivedi, Mr. Shankar Narayan, to say that view section 4 in isolation. Don't view it as becoming a part of 31C. So what I'm trying to deal with that point. Your Lordship, sir. Paragraph 16.
At page?
What is that? Page 111. 111. What the argument that the order and judgment in Minerva Mills merely struck down Section 4 to be unconstitutional and not, it should say, Article 31C as amended by Section 4 is stated to be rejected. Section 4 had, in accordance with subclause 2 of Article 368, resulted in Article 31C standing amended in accordance with the terms of the bill on 18th December 76. So not first is the factual position. From this day onwards, Section 4 was a part of Article 31C and Article 31C stood so amended. Any declaration of unconstitutionality with regard to Section 4 after 3rd January 77 is necessarily to be read as a statement of unconstitutionality with regard to Article 31C as amended by Section 4. Now, look, to this point, please have a look at the order passed in Minerva Mills. Not I've extracted it, but if your lordships will kindly go.
No, but the logic you are trying to make read other. There are 17 and 18.
Yes, sir.
Then it makes sense what you are saying.
Yes, sir, I will. So,
They have already answered. You read para 70, so that
yes,
becomes
17, please, sir. From this day onwards, Section 4 was a part of Article 31C and Article 31C stood so amended.
Now 18.
18. Any declaration of unconstitutionality with regard to Section 4 after 3rd January 77 is necessarily to be read as a statement of unconstitutionality with regard to Article 31C as amended by Section 4. In fact, it is evident from a reading of the order in Minerva Mills that the Honorable Supreme Court also regarded it to be so.